Okay, ladies and gentlemen, distinguished guests, it's an honor for me to welcome you back and to introduce to you our next keynote speaker of the day, Ms. Ceren Mutuş Toprakseven. Ceren completed her BA studies at the Law Faculty of Koç University and is currently doing her master's studies at Ankara University EU Law. Actually, as far as I know, that's completed at this point. She's currently doing her LLM at King's College in Public International Law. She also has participated in a project called Facing the Challenges of Public Research through Training Strategists in the Balkans. In 2010, she observed as official observer by the United Nations Assistance Mission for Iraq and the Turkish Ministry of Foreign Affairs at the parliamentary elections in Baghdad, Iraq. Ms. Toprakseven is a researcher at the International Strategic Research Organization, USAK, as well as the Center for EU Studies, and specializes in public international law, EU law, and Turkey EC Association law. Additionally, she is the editor and columnist of USAK Strategic Agenda, a Turkish e-journal of USAK, and contributes to the monthly bulletin Agenda Europe, published by the USAK Center for EU Studies. The lecture topic that she has chosen today, let me make sure I read it correctly, is Interception of Migrants in the Mediterranean Sea, exploring the legal implications of the Hirsi and others versus Italy judgment of the ECtHR. Ladies and gentlemen, I would ask you to please join me in a very, very warm welcome for Ms. Ceren Mutuş Toprakseven. Thank you. Okay.
Good afternoon, ladies and gentlemen. It is a great pleasure for me to be here with you today and have the opportunity to address in this important conference. Today, I would like to talk about the highly debated interception operations of Southern European states in the Mediterranean Sea and the compliance of these measures with the general protection of refugees. In that regard, I will try to briefly analyze the recent Hirsi judgment of the European Court of Human Rights, which provided a fundamental critique of Italy's pushback policies. I would like to begin my presentation by referring to the story of Daniel, a 26-year-old Eritrean who fled his home country in order to escape gross human rights violations. He undertook an extremely dangerous journey towards Europe with the hope to find a safe haven. I believe that Daniel's testimony is very useful to approach the issue because it not only provides a general understanding of the nature of interception operations, but at the same time gives some insights into the ill treatment that the returned migrants have to face with at the hands of state officials, and in this particular case, the Libyan authorities. Here is how Daniel describes his experience of interception in the Mediterranean Sea and the subsequent events that took place in Tripoli. Let me read you. The smugglers crammed 264 of us onto the boat. There were pregnant women, babies, and children. After 10 hours, the motor broke. We had no food or water. We drifted for 5 days. We were waiting to die. On the 5th day, a Coast Guard boat from Malta came. It gave us some water. The boat nearly capsized because people stood up to get the water. They brought a rope and tied it to our boat and towed us. After 2 hours, the Maltese boat changed direction and took us to Libya. Everyone said, please, no. We pleaded with the Maltese, but they just waved their hands to say no. We saw a green banner of Libya on a fishing boat. The Maltese gave them the rope. Everyone was crying. Water was coming inside the boat. There were high waves. For 20 minutes, it looked like our boat really was capsizing. Then the Maltese cut the rope and they were gone. The fishing boat took us to Libya. We were really tired and dehydrated when we arrived in Libya. I thought, if they beat me, I won't feel a thing. When we arrived, there were no doctors, no one to help, just the military police. They started punching us. They said, you think you want to go to Italy? They were mocking us. We were thirsty and they were hitting us with sticks and kicking us. For about 1 hour, they beat everyone who was on the boat. Then they put us in a closed truck with only 2 little windows, not enough air to breathe. There was no food or water in the truck. It was 40 centigrade outside, but it felt like 80 degrees inside the truck. I thought we would all going to die in there. but somehow we all survived. They then took us to the Misrata prison. First of all, I would like to define what is interception. Actually, there is not an internationally accepted definition for interception, but the concept is understood by the UNHCR as all measures applied by a state outside its national territory in order to prevent, interrupt, or stop the movement of persons without the required documentation crossing international borders by land, air, or sea, and making their way to the country of prospective destination. For the purposes of this presentation, I will focus on the measures of states on the high seas in order to prevent vessels which are suspected of transporting persons lacking required documentation or valid permission to enter the destination countries. And since the Hirsi and others versus Italy will be my main reference point, I will specifically deal with Italy's pushback policies and return policies to fight irregular migration by sea. I think first of all we need to identify the problem, which is articulated differently depending on from which side it is approached. From a state perspective, the problem is seen as the increasing numbers of undocumented migrants arriving in Europe. And there is a lack of political will within the EU on efficient burden sharing. According to the UNHCR figures, the number of asylum seekers in 27 EU member states rose to 280,000 in 2011, a 15% increase compared to 2010. But more strikingly, among the European regions, the largest increase in asylum seekers was reported in 8 southern European countries, which received 66,800 asylum requests during 2011, an 87% increase compared to 2010. In this context, Italy specifically saw a sharp increase in asylum claims in 2011 due to the conflicts in the Arab region and North Africa. In 2008, the country had received 30,300 asylum applications, many of whom arriving by sea. Accordingly, in 2009, it entered into a bilateral agreement with Libya, which allegedly provided the legal basis for pushback policies. As a consequence, the numbers of people requesting international protection in Italy dropped by almost half between 2008 and 2009. In 2010, this trend continued with only 10,400 claims. However, following the Arab Spring in North Africa, this trend was reversed with an estimated 34,100 asylum applications registered in Italy. And this figure constituted an all-time high for Italy. On the other hand, sorry, I should stay here. On the other hand, the state's inherent right to control their borders and their ultimate goal to curb irregular migration was confronted with the humanitarian aspect of migratory flows. From the migrant perspective, the main problem is the indiscriminate response of destination countries towards mixed migratory flows, which include both refugees fleeing from persecution and war and economic migrants who wish to arrive in Europe in order to enhance their economic situations. It is argued that due to the lack of legal channels for asylum, persons in need of international protection had to be a part of this undifferentiated irregular movement. Moreover, interception operations aggravate this situation by posing a risk for the return asylum seekers to be exposed to torture and ill treatment at the hands of state officials, which is apparently in breach of the principle of non-refoulement. Now we can move to our case of Hirsi and others versus Italy. It is depicted as a landmark decision because for the first time the European Court of Human Rights had the opportunity to scrutinize the compatibility of these pushback policies with the protection of refugees and in general with international human rights law. When we look to the facts and party submissions, the case concerned a group of migrants composed of 11 Somalians and 13 Eritrean nationals whose boats were intercepted by Italian Coast Guard vessels on the high seas on 6th of May 2009. Following the interdiction, the passengers were transferred to the Italian military ships and they were returned back to Libya in accordance with the treaty with Libya, Italy-Libya Treaty on Friendship, Partnership and Cooperation. The applicants mainly argued that during their journey back to Libya, they were deliberately told that they were being transferred to Lampedusa. They were not informed about their right to seek asylum, they were not formally identified, and were not given any linguistic assistance while on board. According to the applicants' version of events, once in Libya, they were handed over to the Libyan authorities, even though they asserted their fear of torture and ill treatment. Another important argument of the applicants was that Italy tried to create a no-rights zone for these people and abandon its obligations under international law. Throughout the proceedings, three main issues arose. The first one was whether the applicants fell under the jurisdiction of Italy during the interception operations that took place on the high seas on 6th of May. Secondly, did Italy violate the principle of non-refoulement directly and or indirectly when it returned the intercepted migrants back to Libya? And finally, could the prohibition of collective expulsion be also applied to removing aliens extraterritorially? Regarding the first question, the court tried to clarify the scope of jurisdiction under the Article 1 of the European Convention on Human Rights. Because the existence of jurisdiction was seen as the precondition for contracting states to be held responsible for their acts and omissions imputable to them. During the proceedings, while the Italian government had accepted that the events took place on board of Italian ships, it denied that the Italian authorities had exercised exclusive and absolute control over the applicants, which would establish the jurisdictional link between Italy and the applicants. The government categorized its operation in the context of rescue on the high seas of persons in distress. In its assessment, first of all, the court laid down the general principle, which says that jurisdiction can be exercised primarily territorially, which means that it can be exercised only throughout the territory of contracting states. However, the court also acknowledged that the extraterritorial exercise of jurisdiction on the high seas could be recognized in exceptional cases, especially when the state's actions outside its territories produce effects. Applying this presumption to the instant case, the court concluded that the events in question took place entirely on board ships of the Italian armed forces, and in its opinion, in the period between boarding the Italian ships and being handed over to the Libyan authorities, the applicants were under the continuous and exclusive de jure legally and de facto physically control of the Italian authorities. So the court established a jurisdictional link between Italy and the applicants, so Italy could be held responsible for its interception operations and for its consequences. Regarding the second question, the applicants argued that they were exposed to the risk of torture or inhuman or degrading treatment both in Libya and in their origin countries, respectively Eritrea and Somalia. The court at the outset acknowledged that the contracting states had the right to control their territories and they could control the entry, residence and expulsion of aliens. However, it continued by saying that measures such as expulsion or extradition may give rise to a violation of Article 3 of the European Convention of Human Rights, where there are substantial grounds to believe that the person in question, if expelled to the origin or transit country, would face a real risk of being subjected to torture or other inhuman or degrading treatment in the receiving country. The court summarized the precarious living conditions in which irregular migrants are held in Libya as inhuman. Many human rights organizations and NGOs have reported cases of torture, poor hygiene conditions, lack of appropriate medical care, and the risk of arbitrary return of irregulars to their origin countries. Besides, the court drew attention to the growing xenophobic and racist attitudes towards these vulnerable sections of these societies. Contesting the Italian government's argument that Libya at that time could be seen as a safe country, the court stated that the existence of domestic laws and the ratification of international treaties are not in themselves sufficient to ensure adequate protection against the risk of ill treatment. In that context, the Italian authorities knew or should have known that when they were returned back to Libya, the applicants as irregular migrants would be exposed to ill treatment in breach of the convention, and that they would not be given any kind of protection against refoulement to their origin countries. Moreover, the court also noted that when returned back to Libya, the applicants would have the risk for repatriation to Eritrea and Somalia. The intervening parties, such as UNHCR, in the proceedings had submitted that Libya had frequently resorted to collective expulsions of refugees and asylum seekers to their origin countries, which eventually constituted an indirect refoulement. Finally, regarding the allegation of collective expulsion, the court for the first time accepted the extraterritorial application of the prohibition of collective expulsion under Article 4 of the Additional Protocol No. 4. During the proceedings, the government had rejected the argument by saying that the protection against collective expulsion would only come into play in the event of the expulsion of persons on the territory of a state or who had crossed the national border illegally. That's why Italy tried to conduct its interception operations on the high seas, long before those migrants, those boat people, would reach its national borders. In this regard, the government argued that the relevant measure was refusal, not expulsion. First of all, the court emphasized on the principle that the convention is a living instrument which must be interpreted in the light of present-day conditions. Furthermore, it was essential that the convention was interpreted and applied in a manner which rendered the guarantees practical and effective and not only theoretical and illusory. In this way, the court submitted that if Article 4 of the Protocol No. 4 were to apply only to collective expulsions from the national territories of the states, a significant component of contemporary migratory patterns would not fall within the ambit of that provision. The provision would thus be ineffective in practice with regard to such situations, which, however, are on the increase. Finally, it's a very interesting point that the court concluded that the nature and the special character of the maritime environment should not end up in an area outside the law where individuals are covered by no legal guarantees which the states have undertaken to secure to everyone within their jurisdiction and within their national territories. If we conclude, the Hirsi and others versus Italy can be seen as a breaking point in the legal protection of migrants at sea. Even though the judgment specifically deals with Italy's highly questionable interception operations and pushback policies, it sends two important messages to all destination countries. The first one is that, as you see in the screen, problems with managing migratory flows cannot justify resorting to practices which are not compatible with the state's obligations under the European Convention of Human Rights. Secondly, states cannot absolve their obligations by just pushing back the problem. Rather, they have a duty to ensure that intermediary countries, such as Libya in our case, should offer sufficient guarantees for those in need of international protection. Finally, it should be noted that it is in the interest of the international community to provide effective protection to genuine refugees and promote and find durable solutions for them. Instead of indiscriminate and arbitrary responses to mixed migratory flows, which ignore the specific circumstances of each individual, states should embrace their human rights obligations and pay attention to efforts to strengthen the asylum structures in intermediary countries through humanitarian assistance and political support. Last but not least, taking into consideration of the pressure on specific destination countries, such as in our case, the Southern European states, a comprehensive responsibility sharing mechanism must be adopted. Thank you for your attention. I would like to hear your questions.
Thank you very, very much for, I think, a very thought-provoking presentation. We would welcome your questions and your comments. As always, if you could briefly introduce yourself and stand, that would be excellent. Thanks.
Hello, my name is Leçini Dilöztü. I'm doing PhD at University of Tübingen. I think your topic is really interesting, and I would like to ask you if there are other cases which were brought before to European Court of Human Rights. For instance, Italy is not the only country which adopts pushback policy against illegal immigrants and refugees. Spain, for instance, built a fence in its Moroccan enclave in 2005, and it led to deadly results. Lots of people died while in their attempts to cross the border. And for instance, we're talking about Italy, which adopts pushback policy to countries in which illegal immigrants risk torture, but some countries built detention centers inside their borders in which these people face torture, ill treatment, verbal attacks, and so on and so forth. For instance, Greece is the case. It built detention centers in which humanitarian organizations criticize a lot. And were there other cases like this, similar cases, which were brought before European Court of Human Rights?
You're absolutely right. Italy is not the first country who conducts interception operations, and as a result, it violates the principle of non-refoulement. Not just the Southern European states, but North Africa, Canada, Australia are the other countries who frequently resort to the interception operations. But this case, this Hirsi case, is the first case that was brought before the European Court of Human Rights for the scrutiny of these policies with international human rights law. For example, before that, which was the name of the case, MSS versus Belgium and Greece, it was a similar case that the court stated that the sending states should ensure that the receiving states should provide sufficient guarantees for those people returned back to them. It was a similar case. For example, also in 2009 or 10, I'm not sure, the court concluded on the Medvedev versus France case. Also in that case, the court accepted the extraterritorial application of the European Convention of Human Rights. But this was the first case that was brought by the returned migrants before the court, and as a consequence, the court concluded that the pushback policies are in breach of the principle of non-refoulement and are in breach of Article 3 of the European Convention of Human Rights.
Would like to go next in terms of a question or comments? Don't be shy. This is your conference, and I want to make sure we have as much interaction as we can. So really comments or questions, don't hesitate. Okay, please.
Hi, my name is Michelle Castano. I work at the United Nations in Germany. What I was wondering is, do you know of any statistics or studies that show to what extent these people, these migrants who are arriving to Italy, are actually staying in Italy, or whether they're spreading out through the EU? And if so, also, do you think that this is only the problem of the Italian state, or is there pressure from the European Union also on the Italian state, in terms of threatening them to take them out?
Yes, especially the second part of your question is very important, because during the Hirsi proceedings, the Italian government argued that it was not just the Italian problem. It was the problem of the European Union, and Italy conducted these interception operations and pushed back these migrants back to Libya because the European Union wanted from him to do it. That's why it was his argument. It stated that you shouldn't just target me, but if you begin to scrutinize this policy, then you should criticize the general EU's policies on migration control. That was the case. And you mentioned about, I think, about statistics. Well, studies, there are many studies on this issue, and I think the most important point is that you stated that they spread, do they spread to the other European Union countries? And you know that it created a big problem between Italy and France, because after the uprising in Tunisia, many Tunisian people came to Italy, and Italy, because it couldn't receive a sufficient support from the other European Union countries, began to provide these Tunisian migrants temporary residence permits, with which they could travel to other European Union countries, and it created a big problem. And after that, the European Commission began to study on a proposal that in these emergency situations, the member states could present the border controls individually, and it created a problem. And I believe that it will more create a problem in the future, because it is the main problem of Europe. Europe is trying to push back the problem back to the transit and origin countries and ignore the problem, but it's not the case, because it is migration. You cannot stop migration by just stopping these people on the high seas and sending them back to their countries. They are trying again and again, and at the end they reach the destination countries in summer, but they are undertaking more and more dangerous journeys, and it ends in many deaths. So it's a very critical problem. I think international community should work together and try to find a common solution to this problem.
Excellent, and I think we've inspired two other final questions. We'll start maybe on this side, and then we'll come to the right.
Ali Dirios from Bilkent University, and my question is, since you just ended about the comments on the international community, is as far as I know, there's the UNCLOS, the United Nations Convention on the Law of the Sea,
yes, to
which, as far as I know, Turkey is not a signatory nor a party to it, but it is the most widespread agreement on the laws of the seas, and especially on the high seas. First, is since the issue is about migration and interception on the high seas, are there any what does UNCLOS say about this? Yeah. Currently, and secondly, are they planning to change anything? Thank you.
Okay. Regarding first part of your question, yes, the UN Convention on the Laws of Sea, it doesn't provide a general provision on interception operations, but it provides an obligation for states to intervene when they encounter with a vessel in distress on the high seas. It is states' obligations to help those people on the high seas who are in distress. And that's why Italy argued in its, during the proceedings that we didn't try to implement an interception operations, but it was a rescue operations. We saved the lives of these people, and then we sent them back to their home countries. So you cannot establish a jurisdictional link between me and those migrants. But the court denied this argument. It said that, yes, it is still your obligation to help these people, these vulnerable people in distress on the high seas, but at the same time, you cannot deny that there is not a jurisdictional link between you and those applicants. So you should be responsible towards these people as you are responsible towards the people within your territory, within your jurisdiction. It was the argument. Regarding the second part of your question, actually, I don't have a specific idea on that, whether they are discussing any change on the United Nations laws of the sea, but there are increasing numbers of reports that warning the states to respect their obligations in terms of rescue operations. Because I'm afraid that in the future, because of this judgment, states can become more reluctant to intervene these vessels on the high seas. They can close their eyes to these vulnerable people on the high seas in order to abandon their responsibilities under the European Convention of Human Rights. I think this is the main problem we can face with in the near future. But NGOs, UNHCR, the Council of Europe repeatedly warning member states and warning them to respect their obligations in terms of rescue operations.
Final question, please.
Thank you. My name is Sevda Keskin, and I studied European law in Leiden. I was just wondering that you said Italy, so it's related to the lady's question, you said Italy says that it's EU policy, and so I can just, you know, abandon my obligations. But what about Turkey policy? So it's not a part of EU. So do you think that just you can say that I'm just implementing my own policy and I can't threat, you know, it's my own policy and you cannot judge this one? What do you think about Turkish position in that regard?
With regard?
You said that, if I didn't get wrong, you said Italy says that it's EU migration policy.
Yes.
So it's my own, your own policy under the convention, or maybe. So Turkey has a specific position on that regard, and especially, as you know, she deals lots of cases in Court of Human Rights. So
in the agency?
Sorry?
In the agency, for example, there is a situation between Greece and Turkey. Again, in the agency, similar cases, but there is not specifically interception operations. If you're asking me about Turkey's position, of course, right now, Turkey says that it's my own asylum policy. And for example, it's not my main topic, but I should comment on a different aspect regarding Turkey. For example, right now, Turkey is negotiating a readmission agreement with the European Union. And it argues that, yes, I will sign this agreement with you in the near future, but as long as you abandon the visa requirements for Turkish citizens. I believe that it's not a correct policy, because I think these two are not exchangeable. Yes, there is a right on the part of Turkish citizens to travel to European countries without visa, but it should not be exchanged with signing the readmission agreements, because right now Turkey does not have an efficient and sufficient asylum system. And it's a very big problem. If Turkey accepts to sign this agreement at this point, at this level of asylum system, it will be a buffer zone at the end, and it will not only harm Turkey's position, but at the same time, it will create many bad implications for refugees and return asylum seekers. Because right now, if Turkey receives irregular migrants from Greece, it summarily sends these people back to their origin countries without any assessment, because it thinks that these people are irregulars. It doesn't think on whether these are refugees, whether these are economic migrants, what's the reason behind of their escape from their origin countries. I think the main problem with Turkey is this. I can comment like this.
Thank you very much.
You're welcome.
All right, well, thank you very much. I think on that note, we've got a final question. You've inspired one more, and then I think we do need to bring it to a conclusion just in the name of time, but please.
Good afternoon, I'm Veronica. I'm from Italy, so we have an
nice.
inside, maybe the only one, but I do live in England, so actually, I don't have actually a question, because I just would like to give some information from inside Italy.
Yeah, of course.
So, the problem is that I think that when this happened, I was in England, and I was quite surprised that, for instance, BBC television or Al Jazeera London or ABC World, they didn't give actually information about Lampedusa or Sicily. So every time I called home, they said to me, you don't know about what is happening in Italy. And I said, no, really. So it was actually, I don't want to justify Italian population or how actually Italy cope with this problem, but in a certain way, I was linked with other European states, and there was not so much information about the tragedy and the problem in Italy. Mm-hmm. So I think this was a failure of Italy in the way actually cope with the problem, but I think was also a failure of European Union in the way they cope with this problem, because I think that Italian population was not ready to cope with this, was not well informed. Again, I don't want to justify, but speaking with normal people, not academic people, people in the street, people in the market, they used to say to me, why they come here? Yeah. And they didn't understand the reason behind, but because there was no explanation before, no, actually everything started suddenly, so they were not well prepared. And actually, last year at this time, I was in Florence because I was in a conference about Mediterranean problem, and this was the problem. So there was the Vatican involved, and many politicians and ambassadors, and all the conference, we clapped the hands. We were all of us ashamed about this. But the reality is another story. The reality is the people that actually live there, they don't have the possibility of traveling, of understanding how situation is. And so, yeah, I was really surprised about, as living in UK, this was not actually explored. Or, yes. So, yeah, I don't actually have a kind of question, but I think the main question is that why European Union cope in this way? And also, we don't have to forget that many people came in Italy as the first, Sicily was very close to Libya and Lampedusa as well, but the main target of them was France or Germany, and most of the time they try to go illegally to France and they close the border, and so they stay in Italy. And so some Italian people, they just, in their mind, they thought, you see, the other country, they closed the border, so why we can't close as well? So it was a behavior wrongly from many countries.
Well, you're absolutely right. Really, actually, I'm not trying to I'm not trying to put many pressure on the receiving countries, and I'm not saying that those states are totally wrong. Because there's a problem, they are trying to cope with this problem on their own. For example, Italy, Greece, Malta, these southern European states, they are receiving more than 30,000 people, and they are trying to cope with these people on their own. So maybe we shouldn't criticize them solely. Maybe we should criticize the international community as a whole. But the main problem with Italy is that it applies indiscriminate responses towards these migratory flows. I agree that there are also economic migrants. They just want to come to Europe in order to enhance their economic situations. But there are also people, vulnerable people, who deserve to be granted a refugee status, because these people are trying to escape from war, persecution, and so on. And the Italian society, population, are not informed well. But this is the fault of politicians. They are trying to gain votes by making anti-immigrant statements. But it's not just the problem of Italy. It's the problem of the European Union. It's the problem of Turkey. Maybe right now Turkey is not experiencing a big problem about refugees, instead of, if we put aside the Syrian problem. But if one day Turkey becomes a buffer zone for those people, we will witness many anti-immigrant and maybe xenophobic, racist statements as well. It's the nature of states. But I don't know if we should, all the states, NGOs, societies, think tanks, academicians, everyone has to cooperate in order to solve this problem.
Well, on that note, I think we do need to come to a conclusion. We're already a few minutes over schedule, but as you can see, you've inspired many comments and many questions. So hopefully you'll have a chance to stay a little bit also today. Maybe we can informally ask also some further questions. But on this note, I would ask you all to please join me in expressing our sincere gratitude for an excellent lecture and a very thought-provoking discussion afterwards. Thank you very, very much.
Thank you very much.